Well, the press kept shooting at William Kennedy Smith, whom nobody knew from Adam, and hitting Teddy. And that was good news because it got a huge audience. We don't have any rape in Palm Beach County. We had 3 cases last year. One was dismissed by the cops as silly, one was dismissed by the victim as a mistake, and the other was William Kennedy Smith, which became a full-blown trial. The trial of the century, it was called. I agreed to do a play-by-play for Court TV simply because Steve Brill and I go back quite a way. I would not have made any commentary for anybody, NBC, CBS, or Court TV in the Smith case, except my condition was met. I must watch every single thing that occurs in the presence of the jury. What the jury sees, I want to see before I give any opinion as to why a lawyer may or may not have done, or a judge may or may not have ruled, as you have seen occur. But Court TV is a good idea. I hope it succeeds, and I'm pleased to support it. And this was a trial I thought that might give the American public, if it were explained as it went along, as best a trial lawyer can do that, some insight into what our procedures are really all about, and where they are deficient and why. Evidence is what wins cases, not pyrotechnics by glib counsel who happen to have a better command of the English language than their colleagues or are faster on their feet. Most people would never have taken a case with this many flaws in it to trial. What you don't learn in law school is that David Bloodworth, the state attorney in Palm Beach County, was so pilloried for favoring the Kennedys when David Kennedy overdosed on heroin or whatever it was he was taking some years ago in Palm Beach, not ordering an autopsy, not ordering a full-scale investigation, that the Palm Beach Post went after his scalp, and they have never stopped. And in this case, he may have overreacted. The acquittal rate in criminal cases that are tried across the United States generally ranges from something in the 20% area on an averaging in state prosecutions to 10% or less in federal prosecutions, and probably less than that in military prosecutions, simply because the military weeds people out and does not have as many politically inspired proceedings. By my own research, which is fairly extensive in this area, the acquittal rate in highly publicized, supposedly prejudicial cases that I have tried was over 80%. So the tables were turned. Nobody hated William Kennedy Smith. Indeed, in Palm Beach, we kind of liked the family. Nobody thought that this was Jeffrey Dahmer, a monster that had to be restrained at all costs, that should be convicted whether he was guilty or innocent. But had William Smith been just William Smith, I don't think that a pickup after midnight at the O Bar, which is a very non-remarkable bar in my hometown of Palm Beach, would have caught anyone's attention, except that you put the name Kennedy into it, and all of a sudden the press is inspired to write a womanizing, drinking, carousing, and other conduct of a questionable nature. People don't usually become famous because of their middle names. I never saw the name William Smith in any article. It was always William Kennedy Smith. But they were shooting at his uncle, whose heritage in this Commonwealth, until the prosecution was dumb enough to put him on the stand and lionize him unwittingly, was plummeting very badly. Now, the police in Palm Beach County do only one thing. They pinch you if you drive over 35. The average person in Palm Beach County is 107. And if they drive over 35, they kill everybody, including themselves. So you don't drive over 35. I watch the experts in amazement, and I have called more than my share. Dr. Henry Lee from Connecticut, a distinguished forensic pathologist, a true detective, a brilliant man, is called for what reason? He gives opinion that if a woman running for her life across a lawn is tackled by a guy who's 6'3" and 190 pounds on the move, she'll get grass stains somewhere. They brought him from Connecticut for that, on her clothes, on her body, or somewhere. The pinnacle of expertise, of course, was Dr. Raphael Good. Now, credentials are all important in expert testimony. What was Dr. Good? Dr. Good was a double-barreled shotgun. At age 70, he had managed to get board certified in OBGYN, and psychiatry and neurology. By combining the collective wisdom of these sciences, he was able to give this opinion to an American jury. If an unaroused male attempts to penetrate a dry and unaroused female who is on the move, he's going to have trouble. That's what he said. That was his opinion. You wonder whether they'd ever heard that before. One-on-one is now a feasible case, but it has to carry some credentials with it, or it should not be brought into a courtroom. Gigantic flaws in any proceeding, particularly when the standard is beyond a reasonable doubt, cannot be ignored. And in this case, they were. The Irish of South Boston, where Willie Smith was brought up, learned that a decent woman would say no at least 5 times, and you had to gauge by the tenor of her voice whether she really meant it, but she would never say yes, so you kept asking. Pantyhose are the last bastion of defense, and if they are removed, the manner in which they are removed can be very decisive in any claim of sexual assault. When you get tackled on a lawn and you don't have any grass stains, your story is not credible. When you say I was screaming at the top of my lungs in the nosiest neighborhood in all of Palm Beach that watches the Kennedys in shifts to see if anything's happening over there, didn't hear a word, nor did any family member. I mean, they never have a gathering of less than 100, including a former FBI agent and 2 New York State prosecutors with open windows, never heard a peep. That isn't very good, and when you keep telling the defendant, I think you're Michael, show me your ID again, there is good reason to believe that reality is not part of the picture. Any one of those 4 factors would have been a whale of a hole through which to march a defendant in a rape case anywhere in the United States. As I said to Roy Black, why did you waste all that evidence in one case? You could have won 3 others. One of the most inept prosecutors ever to stand up in an American courtroom absolutely butchered the case. To say silly things like, when are you some kind of sex machine? I mean, this is not cross-examination. Or you want the jury to believe you can do it twice in 30 minutes? This is not attacking credibility. Kid's in his 20s, for goodness sakes. These are mistakes that a sensible prosecutor shouldn't make. To put Ted Kennedy on the stand for no discernible purpose except to have him almost break down in tears over the very genuine loss of his brother-in-law, with whom he was very close, and then hand him over to the defense, where a very well-schooled, highly professional, and well-trained, bright lawyer only asked one question: tell us again how it felt when your brother-in-law died. And he couldn't. Probably raised his popularity in Massachusetts back over the 50% point in that event alone. But that wasn't enough. The worst mistake I've ever seen a prosecutor pull in my life was to ask William Kennedy Smith, who had a good story to which they never had access because they foreclosed the possibility that he could talk his way out of this problem. They made it known, you're going to get prosecuted no matter what you have going for you, because that's the way it is, so they never got any access, no chance to tie him down, unlike Mike Tyson, who went before the grand jury in a desperate attempt to shove this case aside before it got a real bite at his career. This question was put, and I can't imagine that it was ever thought through. It was simply petulant arguing with the witness, and a good example to prove my point that if we don't train trial lawyers in America, we can't expect to get any good ones except the accidental candidates who happen because they do it for themselves. You know, nobody taught the Wright brothers how to fly, but nobody's advocating that you go out and learn on your own tomorrow, not if you want to live very long. You go get a flight instructor to train you to do that. We don't do that in advocacy. Consider this question. Do you want this jury to believe that you had consensual sex on the lawn in your mother's home when her window was open? And the defense answer, she wants the jury to believe that he had violent sex on a screaming woman in his mother's home when the window was open, and a prosecutor and another prosecutor and a former FBI agent were easily within range, as were many other people. That probably did more to produce a rapid-fire thumping verdict than any other development in the case, at least if you listen to reports of the juror.
And then she attacks Will by saying that, are you telling us that you went up on the lawn, put down this towel, and had sex on this towel with this woman under your mother's bedroom window. But what's the other side of that coin? What they want us to believe is that this young man goes up there and rapes a screaming woman under the open windows, not only of his mother, but his sister, of two prosecutors from New York, and the father of one of them who's a former special agent with the FBI. They want you to believe that he ran across that lawn, tackled that woman who's screaming at the top of her lungs under those open windows where his mother is in that bedroom, and rapes her. That's what they want you to believe.
And if the blue blob in front of Patty Bowman's face made her credible when she peeled it off and went head-to-head with Diane Sawyer, who did cross-examine her, Roy Black laid off of her, very frankly, for good strategic reasons. Who did cross-examine her, her sympathy factor didn't rise, it fell. Her answers were no better, perhaps worse, than they had been at trial. I didn't get any flashback in that case that women were unfairly treated. There is absolutely no legal machinery, except in military court, to correct a jury mistake. Nor is there any way to find out how it was made. What is said in the jury room is off limits, absent two kinds of errors which are cognizable. Number one, a juror brings expertise into the jury room that did not come out in the trial because of his or her background, or a juror threatens another juror to the point where coercion can be shown. If they simply act foolishly or believe the wrong witnesses, that's tough. That's why Americans do permit innocent people to be executed, because the jury's verdict must be undisturbed is more important than that it be correct. What really has happened with the big I in the courtroom is, number one, the lawyers do not preen. They perform better. They know that they're going to be watched by a lot of people. They come to court better prepared. They handle themselves in a better way than I had seen them do in days before the camera was present. And I think generally their clients are better represented. The judges are more fair, less apt to be brusque, equestrian. That's what we call a judge who thinks he's a horse and rides all over everybody in the courtroom. They stay awake. I used to love to taunt federal judges in habeas corpus proceedings. Say, Your Honor, you do have some jurisdiction over whether or not the state raped this man's rights, but should you come to the conclusion that he is innocent, you are powerless to do anything about it. But they would practically crawl off the bench and say, who do you think you're talking to? Now, whenever you tell a federal judge he's powerless about anything, you have bitten the tiger in the middle of the tail, and sometimes that's a good way to get him to act. That very issue is finally going up to the worst Supreme Court in my lifetime. I'm not at all optimistic. So wire recorders tucked under the left breast or wherever you can conceal one, and they play on for hours. The problem is, I have never found a way, nor has my more distinguished partner, Mr. Fishman, found a way to cross-examine a tape recording. You're absolutely screwed to the wall. You can't do anything about it. There's your client's voice saying, I'm guilty as hell, and I have no idea a jury will ever hear this, but of course they do. Is it a good idea? That is a cultural question. I suppose it revolves around the right to lie. There is a right to lie. It's an important right. When you walk in and find your grandmother, on her deathbed with one foot in the grave and the other in a banana peel, are you required to stand there and say, look, you look awful, and you probably won't last the night? Of course not. You bring flowers and say words of encouragement that you don't even begin to believe. You say nice things to your professors when you'd like to say something different based on the last grade they gave you, and so on down the line. Is there a right to lie about an important matter in court? I doubt it. I doubt it. Are you victimized if somebody hands you a tape recording of your own words to impeach your false testimony in the witness stand? Maybe in an extreme case, but I doubt it. Is it a dirty business? You bet. A really dirty business. And the reason we tolerate it is because we believe it's only used on dirty people. But the end justifies the means in this country is still alive and well. from little incursions like that that seem a handy way to get a bad guy. Whole barriers of individual rights are ultimately not ripped down but eroded. And that's why the ACLU and others stand the line on what appear to be unpopular causes without much compelling logic behind them, because they don't want to see the barriers erode. And the American Revolution was treason of the most classic kind. If you take a look at the definition of treason in the U.S. Constitution, it is made impossible to prove. Why was that done? Because all the people who wrote the Constitution thought if they lost the war, they'd be tried for treason. And if their rule prevailed, they couldn't be convicted simply because they'd written the rule.